Evidence Act lays down that if no attesting witness can be found, it must be proved that the attestation of one attesting witness at least is in his handwriting, and the signature of the person executing the document is in the handwriting of that person. DW1 initially contested and challenged the will, but later came in support of the plaintiff and deposed that she had seen the original will and the testator was mentally and physically fit when the will was executed. The PW1, being a beneficiary in order to prove the will through Section 69 of the Evidence Act, stated that he was present at the time of the registration and attestation of the will. He, however, did not mention execution of the will by Ralph. This witness has not filed any document relating to his date of birth. Nevertheless, he was 61 years old when he first deposed in the year 2016. Thus, PW1 was 13 years old on the date of the alleged execution and attestation of the will. Further, he could not name any of the attesting witnesses. The learned advocate for the plaintiff during argument has referred to the decision reported in so-and-so, wherein the Honorable Court has observed that Section 90 of the Evidence Act applies to the wills as much as the other documents, and if the court does make presumption under Section 90, proof under Section 69 is not necessary. The present settled law is different. In Ashutosh Samanta D by LR versus Rajan Bala Dasi and others, which relied on the decision of so-and-so, Your Lordship, and the decision of so-and-so, a presumption of execution and attestation under Section 90 of the Evidence Act shall not be drawn in cases of wills. A will has to be proved in accordance with Section 63C of the Indian Succession Act, read with Section 68 of the Evidence Act, and if the will cannot be proved under Section 68 due to the absence of the attesting witnesses, resort to Section 69 can be taken. Here the evidence of so-and-so, so that is why, Your Lordship, the learned lower court says that, Your Lordship, in view of the above discussions, the purported will was not proved in accordance with law, and there are several suspicious circumstances surrounding the alleged execution of the will. Hence, it is ordered that the instant application under Section 278 of the Indian Succession Act is dismissed ex parte, Your Lordship. Lordship, the will was dated 1968, Your Lordship. 1968. Now, subsequently, Your Lordship, they have found one document, Your Lordship, wherein I filed one application also, Your Lordship, under Section Order 41, Rule 27, Your Lordship.
Now, what does it show?
Lordship, in this application, I have annexed two documents, Your Lordship. One is the document which was a receipt, Your Lordship, which they found later on. They had deposited all their articles and documents in the locker of the Grindless Bank, Your Lordship. In one flood, all that was destroyed, Your Lordship. That is the page 5, annexure A, Your Lordship. That is why the original will was not found, Your Lordship. However, we have filed this application on the basis of the certified copy, Your Lordship. This was a registered will. And second is, Your Lordship, there is one affidavit which has been shown by one Mr. Bitan Bhattacharya. He is 79 years old, Your Lordship. And he is from the same locality. And he used to know the persons, Your Lordship. And he knows everybody, Your Lordship. And the attesting witnesses, in the meantime, they have also died. So he is ready to, Your Lordship, give the evidence and prove their signatures, Your Lordship.
No, but thing is this, that there's a 35 years delay in filing it.
Lordship, what had happened was, Your Lordship, it was not available, Your Lordship, for a long time, Your Lordship. The will was not available, Your Lordship, for a long time.
How did you get the will?
Subsequently, Your Lordship, we got it from this thing, from the registered office, Your Lordship, registration office.
So registered.
That was the case. It was a registered will, Your Lordship.
Now, who was the executor?
Lordship, I have said so, I think so.
According to the plaintiffs, the natural heirs of
Your Lordship. Order itself, the first page of the order, Lordship. Lordship, the second paragraph, it has been averred in the application under section 278 of the Indian Succession Act that one Mr. Ralph Seymour Shaw died on 2/9/72 at 5 Fakir Pada Road under P.S. Behala. He had executed a will on 1/3/1968, and the said will was duly attested and registered. He had appointed Filey Shaw, Joykali Pon, and Sumitra Pon Chetri after marriage as joint executors. Sumitra Chetri is present, is the present defendant. It is the further case of the plaintiffs that the original will was lost from the custody of the plaintiffs, and they were compelled to obtain the certified copy of the same. It is also averred that the
Now, what is your name? You are Bhakti Pan.
Name of the appellant.
You are the appellant is asking.
Yes, Your Lordship, I am the appellant, Your Lordship.
Bhakti Pon.
Lordship, the Bhakti Pon and his brother, Your Lordship.
Claims to
They are the beneficiaries, Your Lordship.
Now, Bhakti Pon claims to be the child of Joykali,
Joykali, Your Lordship.
and Sumitra is the adopted children.
Sumitra is the daughter, Your Lordship. Sumitra was the daughter.
Daughter
Sumitra,
of
Bhakti Pon, and the other person, Your Lordship.
no. It says who were the biological children of Joykali and Dhanjit. Who is Dhanjit? Dhanjit is the husband of Joykali.
Joykali was the wife of the testator's caretaker, Dhanjit Pon. She is not testator's wife. Joykali was not the testator's wife.
And these three were adopted by whom? Adopted children of the testator. You claim that they are the adopted children of the testator. So it was a fight between the legal heirs of
Biological children.
of Joykali and Dhanjit. It's a fight between
Lordship, initially, Lordship, the daughter, Sumitra Pon, she was fighting the case here, Lordship, but subsequently she is with the...
No. It's a fight between the sons and daughter of Joykali.
Joykali, Lordship. Mr. Files, he was an English gentleman, Your Lordship, and they were staying with them. Even after 47 also, the gentleman didn't go back, Your Lordship.
So attesting witnesses were not there.
He's not there, Lordship, because long back, Your Lordship.
So how
they were
how
from
you-
Bombay. They tried to find them out, Your Lordship. They were from Bombay, Your Lordship. But the gentleman was there, Lordship, Bitan Chandra Bhattacharya, Lordship. He was there, in fact, Lordship. Later on, they found out.
So
And the main reason was, Your Lordship, the
testator-
appellants, they were not properly, Your Lordship, guided by the...
testator appellate-
They relied on section 90. They thought that...
ওরা করেনি তখন, প্রডিউস করেনি। এখন then
I have served, Your Lordship. I've served. It
that
is only one distinction.
serve করিস না?
One copy.
আমি serve করছি।
to Mr. Chitra. All this will
Yes, Your Lordship.
no track report is right. Troy. It has been
Page, your lordship.
registered, but why is the
Oh, that has not been annexed, your
tax report? So
Incomplete service. Service incomplete. You have to show,
that was not taken out, your lordship.
take out.
May it please your lordship. There was a direction on us.
Yes.
This is the eviction matter where your lordship had asked for exhibit F.
I am representing
We
the
had-
appellant,
Certificate copy of it.
Milord.
Kindly see
Milord,
the last
this
order.
is, Milord, arising out of the eviction of Milord trespasser. We say, Milord, I say, Milord, that I am not a trespasser, but I am a tenant. in
Yes,
this
give us exhibit F.
Kindly see the schedule from where we purchased the property from the erstwhile owner. The schedule. That is what your lordship wanted to see.
আমি দিনে order করে নিই।
Order নেই।
Second
They had gone before the rent controller where their case was dismissed. They did not prefer an appeal. That is what your lordship wanted to see.
Oh my gosh. Too much time. Sorry. The subject is hold out. It's one of the landlords. Those pointer.
rent control জমা rent control জমা deposit or deposit of rent before the rent controller was
Yes.
rejected.
Now, Milord, initially, Milord, the rent controller rejected my prayer only on the ground that they have purchased in the year.
Have you challenged that order of?
No, I have challenged in civil suit. A civil suit of declaration of my right title interest as tenant has been filed. That has been rejected by the city civil court on the same ground, and that has been challenged before this honorable court, filing an appeal. That is also pending. FAT 298 of 2024. And this decree has been, this suit has been decreed, Milord, earlier to the, before the decree of this eviction suit. So I already challenged that decree, and that is pending. FA 298 of 2024, filed on 17th of September 2024.
We don't know.
Now, Milord, the point is,
Why
Milord,
this case, this appeal was filed?
Milord, yes, Milord, this is filed on 18th of June 2025. Decree passed on, in present appeal, decree, Milord, passed on 17th of April
If the
2025.
rent controller matter, if the rent control order is not a challenge, then you are a defaulter. Whoever.
No, not on the ground of defaulter. the rent control rejected my application on the ground that the person who
Did you-
issued
did
the rent receipt in my favor, whether that person is a co-sharer or of the property or not.
Did you then approach the civil court for depositing your under 7(2)?
No, that question of 7(2) and 7(1) comes if the landlord filed a suit for eviction. Until and unless,
So he
under
has
the
not filed-
97 Act, your lordship knows better than me.
Not filed a suit for eviction.
It's a
No,
title
they
suit,
filed a suit for
trespasser,
trespasser. They filed a
trespasser.
suit for trespasser. They are the purchaser, subsequent purchaser of
Yes.
2011.
Schedule
So
your
they are not aware of the original owner. Actually, I was in possession by the original owner in the year 1987, and they have purchased in 2011. We have exhibited every rent receipt in the suit.
He has also, certainly he has purchased from original.
No, that is, I am not, because they did not produce their purchase deed. Rather, we produced their purchase deed,
Exhibit F.
and that has been exhibited at our instance.
Kindly see the
Exhibit
schedule.
F.
No, exhibit F, they have already produced the document. Why you said they have not? They
Milord,
produced the document of
Yes,
title.
we are not denying their
Title.
title.
You cannot.
We are
deny.
cannot be.
Yes.
What I am not praying, but what the tenant has prayed before the
You
court.
have to have either you are a tenant
Yes,
or a license.
or a trespasser. No, they have.
Tenant, licensee, trespasser, whatever.
Yes.
You say you
If
are
I
a
am tenant,
trespasser.
if I am tenant, if I am tenant, I have to be
So how they
evicted
became a
under
trespasser?
the 97 Act by filing eviction suit, not license.
Saying he's a trespasser. That is why your lordship asked for the deed. Kindly see the schedule. Occupied portions with strangers and or trespassers. This is what your lordship wanted to see, because there's a finding here upon their own admission, Exhibit F. The trial court has made extensive findings on the
No,
taking-
document may say licensed trespasser. But that itself, when you file a suit, you have to establish that they are trespasser.
They
That-
could not produce any document to prove that they were tenants. On the basis of the documents, kindly see the
Not everything
extensive
produced-
findings.
Rent
Extensive
receipt-
findings that he is a
rent
trespasser.
receipt produce and the
See the
document
findings.
to believe that I was inducted by the erstwhile owner, that has also been produced,
If
and that
he-
has been exhibited.
If he claims
But
to
the
be a
learned-
tenant, he has to prove on documents he is a tenant.
If your lordship kindly
He-
allow me, I can place the case, my lord.
Now, what was the reason for?
Your lordship, yes, your lordship kindly sees impugned, my lord, decree, judgment, page 13 on, yes, my lord, page 13 onwards.
He could not prove the landlord-tenant relationship.
Appellant issue number 5678. If your lordship kindly get the first issue number 5, whether the defendant was inducted by one Dilip Kumar Nath with respect to the suit premises as a tenant in July 1989. This is the first issue. If this issue has been decided correctly, then I will be established as a tenant. My status would be tenant, and in that score, under 97 Act, they have to evict me.
So who will prove this issue?
No, your lordship kindly sees this.
It is your duty to prove.
Yes. I have produced.
Prove.
I have produced the document. Your lordship kindly sees what the landed trial court are in law and fact. Your lordship kindly sees page 14 onwards. The observation of the landed court. The bottom portion, paragraph A, tenant
See,
cannot change.
you should show some title, some
Yes.
semblance of your right in respect
yes.
of the vis-a-vis him. If you have you may have a better title than him. You may have some title to show, resist your claim.
Yes,
So
as a
what
tenant.
document?
As a tenant.
Yes, what is the tenancy? Nothing.
Your lordship kindly see. That is why I'm
What?
showing your lordship the observation of the landed court.
Yes, before the rent, prior to the rent controller, what document you have shown that you are a tenant?
No, rent receipt was produced. Rent receipt, your lordship kindly sees.
That rent receipt is Bola Lord, that you have not. been able to
No. That whether Dilip Kumar Nath and Dilip Kumar Boral,
Are the same person.
this problem was cropped up, and the landed rent controllers think that since this dispute is there, I'm not going to decide, or I'm not going to accept the rent. So go before the court. I went before the court. I filed a suit for declaration of my tenancy right, and
But you are a tenant under whom? Nath or Bola?
under the present owners, they are now.
Present owners have purchased the property.
Yes, they have
So you
purchased.
said your landlord was Nath or Dilip Kumar Nath or Dilip Kumar Boral.
Yes,
Neither could be traced. Neither one was traced.
no, that
What
is
is the veracity of the rent
you-
receipt that you have
that is
produced?
that is why some documents has been exhibited, not only rent receipt, subsequent letters of one of the co-sharers were there, wherefrom it will reveal that Dilip Kumar Nath existence was very much there. That is why I'm trying to point it out.
That letter was proved.
Yes, that is exhibited,
no.
and that has not been
Wait,
challenged.
wait.
Your Lordship, kindly see the letter first.
No. The evidentiary value has to be assessed at the time of writing judgment.
Your Lordship, kindly
If
see.
that has been exhibited.
Now, Your Lordship, kindly first, my Lord, see the judgment itself.
Yes.
The observation,
Document, which document?
my Lord, Exhibit C. This is the document. Kindly excuse me, my Lord, this is only one copy. This is, my Lord, admittedly, this letter issued by one of the co-sharer from whom they have purchased. If Your Lordship kindly see the deed itself.
In your in your suit for declaration, have you made them parties?
No. My Lord, that the person has already died. They have purchased it from that person, Sitanath. Now, since my landed friend has just handed over the deed by whom they have purchased it, one of the party is the son of Sitanath. And that Sitanath identified me as a tenant of Mr. Dilip Kumar Nath. And that later has been exhibited and not challenged by the opposite party. Plaintiff.
See the findings as to the letter, page 15.
Lord, I will show the findings. I will show the
This is
findings.
not a letter saying that you are my tenant. This is just saying there are disputes between the landlords. Please kindly see the findings,
Kindly
page
do
15.
not pay the rent. Kindly do not pay the rent since dispute is there.
So,
Co-sharer who is admittedly sold the property
Declaring the occupants.
to my landed friend's client.
Sitanath or something like that is actually one of the co-sharers.
Yes,
So how can you prove this?
and one of the co-sharer wrote this letter to me
Yes,
that since you are the tenant
So
under.
till 97 you paid rent
Yes,
to Sitaram Chandra.
yeah, no, not Dilip Kumar Nath. Your Lordship, kindly see the second paragraph. That Sitanath has identified me as a tenant under Dilip Kumar Nath. He said specifically
Why
that
they should go in such a cumbersome way?
no, that is that is exhibited document, that is proof. Because your Lordship knows 1987, there were several co-sharers.
Sitaram has written a letter to Ashok Datta.
Yes.
One of them,
Or
you are Ashok.
me, yes,
You are Ashok.
to my client.
To inform you that I can read, I'm one of the owners of the premises and such. On the death of Dilip Kumar Nath,
Yes.
such and such.
So you are requested not to pay the rent since.
So prior to 1987, how you are paying the rent?
No, my Lord, I have been inducted in the year 1987.
This is rent receipt.
97.
No, rent receipt is there. Rent receipt is there.
Where?
Prior to 97, whom you are paying the rent?
Dilip Kumar Nath.
Where are those rent receipts?
And those rent receipts are there, exhibited A series. Your Lordship kindly sees the first, the judgment where
Dilip Kumar Nath is related to Sitaram Chandra.
Sitanath is admitted co-sharer. They have purchased it from Sitanath also.
Fact has been proved by you that he is a
That
co-sharer.
Dilip Nath is a co-sharer.
Yes.
Which document would show that he is a co-sharer of the property?
Your Lordship kindly sees, there are, so far as the rent receipt is concerned, that is there.
How you show? Suppose today I say, I am a co-sharer of courtroom number 1.
Now, my Lord,
Don't pay this
your
to
Lordship
him.
kindly consider this thing. I'll consider this aspect.
First, you show that your title is clear. You may be innocent. Your
No,
title has to be
title
clear.
in respect of tenancy. My Lord, I am a tenant.
Sitaram, and have you written to the other co-sharers that because of Sitaram's communication, I am not paying rent to you?
Yes, that is there. It's
Where?
not only
Show us
me.
a single document.
No, I have stated in my written statement that since that Sitanath, one of the co-sharer, requested me not to pay the rent to Dilip Nath, since after the Dilip Nath there are dispute to whom it is to be paid. That is why I did not pay the bill.
After 10/4/1997, you did not pay.
No, not paid.
Prior to that, where are those documents?
Not Exhibit A series. Exhibit A series.
Dilip Nath কাকে দিয়েছে?
But I will prove, my Lord, I will satisfy if your Lordship, my Lord, direct.
Prior to 97, you are paying. So after Sitaram's letter, You are not paying.
No,
You
no.
are not
That
required
is
to pay.
fact. That is fact. I cannot
You are
go
not
beyond.
required to pay.
No, I have
No.
to. I have. Your lordship kindly consider as per
No,
tenancy.
you have, that is why I'm considering that after 97, just because one of the co-sharers says that you don't pay, first of all, you have not been able to establish that when Sitaram wrote this letter to you, there are other co-sharers, which includes that what is that, Dilip Nath.
Dilip Nath.
That is
Dilip
not
Nath already
established.
died.
That is not established.
No, your lordship kindly,
Dilip Nath was a co-sharer where from?
your
It is
lordship
established.
kindly say,
Now, who is your vendor?
if I am not paying rent,
There is,
if I am not paying rent, the
Right.
97, 1990, your lordship knows very well.
kindly.
If there is a first provision, first
Chandra.
defaulter, I will be called as a first defaulter, and I will get the opportunity to pay the rent under order section 7(1) of the West Bengal Premises Tenancy Act 97.
And
If I am,
and
Milord,
Sitaram was what is the name of that?
Milord, I may be a bad tenant. Milord, my respect to submission is, I may be a bad tenant. I am not paying rent regularly. But that doesn't mean that they can evict me without due process of law. Milord, I am a tenant. They have to file a suit for tenancy, Milord, under the Tenancy Act, under section 6.
So
And
he has-
I will certainly get the opportunity
he has
to pay
filed
the.
an eviction suit.
No,
against you.
for trespasser.
That is different.
Well,
That is
he is
letters.
treated as
I'm tenant. The eviction
that
of
tenancy you have to establish. Once the discharge that you have, that you are a
that
trespasser.
is why, Milord, I filed a separate suit for declaration of a tenancy right. And that has been rejected. I preferred this appeal before this honorable court. And that is
And
pending.
moreover, their vendor is not Sitaram.
No, vendor
Sitaram is not their
Your Lordship,
vendor.
So
kindly
why
consider
not-
this.
Nowhere Sitaram, nowhere name of Sitaram appears
No.
on the record as a co-owner.
Yes. Appear.
Well,
Your Lordship, kindly see my
No,
landlord
that
just
is
handed over the
misleading
deed.
report.
Your Lordship, kindly see the deed.
yes.
Deed. Page 2.
Prashanto, Probir, Subroto,
Page 2, point 12. Your Lordship, kindly see the 12. 12
Tapos.
and see the father of Tapos.
What Tapos? কোথায় তাপস?
Billroto.
এটা কোথায়?
তাপস না তপন
তাপস।
তাপস কোথায় আছে? তাপস দেখছি না।
এই,
2, Milord, page 2.
what to? কোথায় কোনটা দেখাচ্ছে?
son of Sudhi, son of
শ্রী তপন
son of
কুমার
Sudhi.
চন্দ্র। হ্যাঁ,
দেখালো।
Sudhi,
তারপরে?
Billroto.
তপন কুমার
এই 11. Your Lordship, kindly see that 11.
সোমনাথ চন্দ্র।
11.
Son of late Sitanath Chandra.
এটা কি
Yes.
সেটা কি করে লেখা?
Very well.
Your Lordship knows at
So,
that point.
so one co-sharer writing to you, you can stop paying your occupation charges.
Yes, Your Lordship, kindly visualize this.
সোমনাথ চন্দ্র।
The provision is to file an eviction suit against the tenant has been prescribed in the Act of 1997. And if he filed a separate suit for eviction of trespasser, that will become nullity because I am tenant. I cannot be evicted by a suit for eviction of licensee or as a trespasser. I will be guided under the 97 Act. The suit is absolutely wrong suit.
Sitaram, you have been paying not to Sitaram.
No, I am not paying to the Sitaram.
If you are not paying it to the Sitaram, then there is,
Since Sitaram has filed.
that means you are a subtenant.
No. Sitaram,
You are
Dilip
paying
Nath,
it to
they are
Dilip.
all co-sharers.
You are paying it to Dilip Kumar Nath or Dilip Kumar, what is the name?
He tried to
Kumar-
make out a case that he's paying to Dilip Kumar Nath.
Dilip
And
Kumar Nath, I am paying from the
Dilip
very
Kumar Nath or Dilip Kumar?
Dilip Kumar Nath, Boral, not Boral, but Nath.
So Dilip Kumar, if you are paying it to Dilip Kumar Nath, that means there is a creation of subtenancy.
No,
No, Dilip
he
Nath
is one of the co-sharers.
that-
He
that-
has inducted me.
No, Dilip
Dilip
is a
Kumar
co-sharer.
Nath, yes.
No, he
Ju-
could not establish
Your
that.
Lordship kindly sees Dilip
Where
Kumar.
from you get, from the vendors list,
Yes.
where from you get Dilip was a co-sharer?
No, Dilip Kumar Nath, there is no name mentioned in the
See.
said deed. But the Sitaram, your Lordship kindly visualize.
Forget about
That is
Sitaram,
true.
show us
Your
Dilip
Lordship,
Kumar Nath was a co-sharer.
Your Lordship kindly sees, even after the eviction, after the
I asked you a
decree,
simple question. You show us Dilip Kumar Nath was a co-sharer.
your Lordship kindly sees the letter I have shown your Lordship, Exhibit C. That one of the co-sharer has specifically stated to
And there
me.
is nothing to show that on the basis of this you have written to the other co-sharers that hence I am not tendering the rent to you.
Yes, because if I am not tendering the rent, Your Lordship, kindly, Milord, consider this aspect, Milord.
Observation আছে।
If I am not, Milord,
You are all tenants under said Dilip Kumar now. नहीं ना, वो प्रमाण করে দেবো।
How you prove
Milord-
this letter?
How this
How you prove this letter?
Your Lordship,
Sri-
Milord,
Sridhanath
Exhibit
Chandra.
C, Exhibit C.
How you prove this letter?
Milord,
But
that
I have
has
How
been-
you prove the contents of this letter?
whether anybody was called for
Have
from
you
the
called,
side Sridhanath
have you
Chandra
called
or
Apurva, Archana,
Milord,
Tapushi,
that
Uttam?
is, Milord, that is to be, Milord, decided, Milord. I did not go into
We
the
ask
fact.
you.
No, that has been, Milord, Milord, your Lordship knows, Milord, in evidence, Milord, Milord, it has been tendered, it has not been challenged by the opponent.
It
It has,
does not mean that if it is not tendered, the contents are to be proved by
Yes.
other evidence.
Milord, the old
Strictly by
document,
party,
no challenge was made by the, either of the
You have to
parties
prove-
that,
You are claiming a tenancy right. So you have to prove that this contents of this, because your case is
Milord, at
on the
this juncture, Milord,
listen
London
to
trial
us.
court did not call.
On the basis of this document, you have not tendered rent to any of
Milord,
the.
London trial court did not consider this is a wrong document, this is a false document.
তাহলে কি হবে?
Your Lordship, kindly consider.
Exhibit হলো।
The learned trial
Consensus-
judge at the time of deciding this did not, say that this is a false document. This has
What
been
about-
allowed. Your Lordship, kindly sees the observation of the learned court.
This document itself cannot go as an evidence of the contents of the document.
That in that case, Milord, I have to satisfy your Lordship means, Milord, showing not some, Milord, judgments, your Lordship.
Judgments, what does judgment say? Let us understand.
Not
Let us
now, Milord.
understand the judgment.
Milord, threshold, Milord,
Judgment says
your
that
Lordship
once
knows, Milord,
once
first
the
appeal is to
document
be
is
hard.
marked as exhibit,
Your Lordship, kindly,
contents proved.
kindly
Then
consider
please
this.
educate us on this.
Kindly consider, Milord,
Will be
this
highly
first appeal
obliged
is,
if you can show us
first
this.
appeal is required
The
to be hard.
contents of the documents are proved.
Milord,
merely
kindly
because the
consider,
exhibit is
Milord,
the
kindly consider, I bow down to your Lordship, kindly consider this. First appeal is to be heard by preparing paper book and others, Milord, and that apart, Milord, another appeal which is pending. That is also my coming, Milord, from declaration of my tenancy right.
That was dismissed.
No, that is pending.
so why you have not
Both the
No, the suit for declaration was dismissed.
dismissed. Thereafter, I preferred the appeal, statutory first appeal, Milord, that is to be heard. Your Lordship, kindly hear
This is a-
both the appeal together.
This is a decree for eviction.
This is a degree for eviction of trespass.
The first appeal that you have filed
Yes.
for declaration, is there any stay?
No, that is
Very good.
initially filed.
why you have not prayed for
File,
stay?
what?
No,
Have you filed that?
I have filed 298, FAT number 298 of 2024.
Yes,
That is
so,
filed.
so have you filed any application for stay?
No, section 5 is there.
How many, section 5?
9 or 10 days
So
delay.
that appeal has not been admitted as yet?
No, statutory appeal is not required to be
No, no,
admitted.
section 5,
No, section 5 is required to be heard.
then you kept it 1 year pending.
No. 2024, that has been
Yes, so
filed.
today we are in August, September.
Application filed within time. As and when the
Application was allowed, have you mentioned?
it has been mentioned, Milord, but it has not come before your Lordship.
You
please.
mentioned all matters are coming and your matter is not coming.
This is your Lordship cannot adjudicate, Milord, prejudge this issue, Milord, sitting there.
No, we,
Your Lordship, kindly, Milord, consider this thing.
we know the reason why we know the reason why those application was not mentioned.
No. The 7 or 8 days delay. Your Lordship knows,
Why you have not in that matter asked for stay?
not stay.
That
out
would have
for-
made our task easier.
that point of time, no execution was filed because execution
Yes,
filed now.
that is the point.
Yes,
No execution was filed.
yes. This execution, if,
Yes,
if
so-
no
so-
execution is filed, then how could
No.
I pray for stay?
Well-
Execution
The
filed
law
now.
is then only when the execution is filed, you have to file for stay.
Yes.
Unless
the law.
your status is determined as a tenant,
Yes,
Yes.
you should have prayed for.
Is it the law that when the execution is filed, then you file a stay?
You are claiming that you are a tenant, and they are proceeding that you are trespasser. So this was your duty to stay this suit.
That
Because
has not been, that has not been
is our
filed.
question. That is
That has
our
not been filed,
point.
but Lord, the fact is,
Now,
fact
under-
remains.
yeah,
Yes. Lord, but the fact remains, Milord.
We have not even tried to have that particular appeal moved for almost 1 year.
No, Milord, that has been mentioned. Milord, as I'm not, I have to take instruction
All
whether
matters are coming,
that has
your
been
matter is
mentioned
not
or-
coming. When did you mention? Please tell us.
your Lordship
Show us
kindly,
the list.
kindly do.
No,
do
please,
not-
please. If you
Because
say you mentioned and we have
September-
not listed,
No.
please show us.
September now it is September. Your Lordship kindly sees 1 year.
All matters,
I
all
cannot-
order 41, All matters are being listed.
At
All
that
are
point
called.
of time, your lordship was not under jurisdiction of this first appeal, if I am not wrong.
Whoever was there, the earlier bench,
That is true. That
bench
is true.
did
That is
not keep any matter pending,
That
as
is
I
true.
know.
That is true. I am not going into that.
If you are not going, then that is a factor to be considered, because you are not, that's a prior appeal. If you are not getting stay, we cannot stay this.
So
It's
that-
depending, see, no, our prima facie finding on there will have a bearing on this.
Your
If
lordship,
we have not obtained any stay,
your,
then you cannot,
your lordship kindly fix
we cannot
any
say
date
this.
before puja vacation, any date. Fix that appeal.
will not take eviction, you know. Will not grant any stay. Will not grant any stay.
No, your lordship kindly hear this matter.
Will not grant any stay. Whatever the execution is there, take down. বলবে আমার appeal pending আছে।
Serial number 35.
35, my lordship, I appear for the appellant tenant.
Milord, I am for the landlord, Milord, respondent.
Sir, this was a suit under section 2G. The only primary defense that the suit is not maintainable under section 21, this is a Tika property. Lord, kindly takes up the admissions. At page 35. At page 36. And only one issue was that, Lord, since the learned court held that there is no as such dispute between a Tika tenant and a Bharatiya, the civil court has jurisdiction. Lord, a simpliciter point of law. Lord, in this regard, Lord, the learned court below, Lord, had not addressed the point of section 8 subsection 2. Lord, the section 8 subsection 2 clearly states, Lord, of the 2001 Act, Lord, the moment I raise the question, Lord, whether I am a Bharatiya under the Tika tenant, Lord, the civil court, Lord, has no jurisdiction.
As soon as you raise the issue.
Raise the question. Lord, section 8
raising-
subsection 2.
Raising your question.
On raising that question, Lord, this has been affirmed by the division bench of our High Court.
So they will not getting chance to revert your.
Lord, this issue, my lord, initially at the time of filing of the suit, my lord, they stated that, I'm sorry, my lord, they stated that they are the landlord. My lord, we filed written statement. My lord, during the time of cross-examination, my lord, the PW1 volunteers that this is a Tika property. My lord, in order to see, my lord, whether it is a Tika property, I made an RTI application. My lord, from the RTI, my lord, the Tika controller stated, yes, this is admittedly a Tika property, the plaintiff is a Tika tenant. My lord, at this point of juncture, my lord,
A simple answer, Milord. My junior Milord has addressed the issue. Kindly takes up section 8 once. Section 8 suggests, Milord, that the monthly or the other periodical tenancy of Bharatiya. Milord, there is no dispute. He is also not saying that he is not a Bharatiya under me. Instead, Milord, your lordship knows, landlord tenant in Milord West Bengal Premises Tenancy Act, just the reverse. It's the Milord the Tika tenant and Bharatiya. What happened, Milord? The section 8 subsection 1 is very clear. The monthly and other periodical tenancies of Bharatiya in respect of the structure occupied by them on payment of rent to the Tika tenant shall, with effect from the date of coming into force of this act, be governed by the provision of West Bengal Premises Tenancy Act 1996. So my original Bharatiya goes, he died, 5 years lapsed. It's post 2002. I applied, Milord, the definition as per Milord, the act applies West Bengal Premises Tenancy Act, treating him to be a trespasser since his right goes. Learned judge has decided that aspect.
When he died.
Milord, he, yes, Milord. Kindly takes up, Milord, the judgment. Milord, he died.
2006, Lord.
2006 he died. So, Milord, Karnani property will not help. I also seen that. If
If
this
your
is a
lordship
simple
not
question,
satisfied, my lord, may I place the judgment of the division bench?
Milord, there is no quarrel with regard to this proposition. If there is a dispute with regard to that, he is not saying, he is saying the character of the property is a Tika property. Very well. Section 8 says, even if you are a Bharatiya, Premises Tenancy Act will govern.
Paragraph number 8, lordship.
এখানে তো
Lord, paragraph 8 onwards it starts. Lord, it states that what is clear and evident from the plain reading of the plain that the property itself is a Tika property within the meaning of 2001 Act. The appellant had been living in the property since birth and he admitted that his father was a Bharatiya. In view of the clear and unequivocal admission, there was no impediment in the court below to decide whether the suit in question was hit by the section
yes,
21.
I bow down.
There was no need for any trial. That is 711 stated. In view of the above, the findings of the court below that a dispute with regard to a Tika property within the 2001 Act cannot be entered into by a civil court in view of express bar under section 21 of the said Act cannot be faulted.
Because there, Milord, the existing Bharatiya was directed to be evicted by virtue of filing the suit. There, Milord, the Tika controller have exclusive jurisdiction. But here, his character to be Bharatiya goes after 5 years. So I treat him as 2G regular suit for eviction. before the general law under section 9 of the Code of Civil Procedure.
Not here
He
in,
could have taken that benefit. No, I am still a Bharatiya, so Thika controller lies the jurisdiction. Here his character as a Bharatiya goes after 5 years.
kindly say
That is
para
not the
11.
case over there.
The
Subject
plaintiff
to
has
correction.
not claimed any independent title than occupying the property since birth. The counsel for the plaintiff places an order passed by the Tika controller in miscase number such and such, where Tika controller held that plaintiff was not a Bharatiya. He has no jurisdiction to entertain the application for eviction under the Tika Tenancy Act. This was the issue here also. This court, however, has no hesitation, however, to record that since plaintiff was claiming right of occupation of a Tika property essentially and only through his late father, the original Bharatiya, the Tika controller, was indeed authorized to decide upon the eviction of the applicant.
Question is this: the matter is sent to the Tika controller to find out whether it's a Tika property or not.
Admitted Tika property.
Admitted Tika property. So the relationship between the Bharatiya and the Tika tenant will be governed by
West Bengal
the
premises.
West Bengal premises here. If that applies, the moment the Bharatiya dies, then if the
Definition of 2G applies.
in the relationship of West Bengal premises here, 2G will come into effect.
2G will come into effect. Here I am on the question of the forum. West Bengal premises tenancy act will definitely apply. There is no quarrel about that in view of
So that
section.
will be decided by the 2G will be applicable by the Tika controller or
This has been held, in that judgment. In that judgment, they have prayed, before the civil court, the civil court had dismissed the suit
Here,
under order
it is
7
not a
2011.
2G case.
The Tika controller held that it was a trespasser. I have the jurisdiction. The Honorable High Court, in the division bench has stated, no, the civil court will not decide that issue. The prima facie have to satisfy whether he was actually
now, what is the jurisdiction of a Tika controller?
the
Let us
Tika
see.
controller has to decide. Kindly consider
The
section 8
Tika controller has to
subsection.
decide whether the property is a Tika property or not and whether it's a Tika tenant.
Kindly consider 8 subsection 2 once.
Tika tenancy after the what is the jurisdiction of a Tika controller? Let us see. What was the provision?
Section 8.1 and 8.2, your lordship kindly takes.
No, what is the provision for Tika controller? Power and function of Tika controller. What is the section?
The power of the controller is at section 11.
Section 5, subsection 3, my lord. If any question
Same
arises
power as
as
that
to
of the
whether
civil.
a person is a Thika tenant or not, or whether the land in question is a Thika land or not, the controller either on its own motion or upon receiving any information may, after giving the person interest and opportunity of being heard and after examining all such documents and particulars as may be considered necessary, inquire upon and decide such question.
So this is a specific power of type 3.
Kindly consider 8.2 once.
Yes.
Section 8, subsection 2, with the paragraph 13 of that judgment.
Rather, I will invite your lordship to stress upon subsection 3.
Monthly and other periodical tenancies of properties and structures.
That the court has to cross the issue of 8.2. Kindly see 8 subsection 2. If a question arises as
Subsection 3 is very specific. If his character is blood answer. এটাই ও দেখাচ্ছে এটাই দেখাচ্ছে
that first the question of whether he is a Bharatiya or not, if that question arises, then controller will have a say.
Lordship.
I am grateful, my lord.
So you are saying no, because of 2G, he cannot claim as a Bharatiya.
Because his predecessor, I admitted to be a Bharatiya.
Huh?
Yes.
If he raises a defense that I am a Bharatiya, then 8.2 would apply.
But I'm coming, my lord. Kindly take
No, so
subsection 3.
What is this? No, I have seen that.
Your
So
subsection,
eviction of a Bharatiya,
my lord, yes.
so eviction, you are saying that by reason of the application of the Premises Agency Act, he cannot claim himself to be a Bharatiya.
Mine.
Now, in his written statement, did he say that I continue to remain as a Bharatiya?
My lord, here, my lord, I join one, my lord, I differ from this issue. My lord, in the written statement, my lord, initially I have not stated. My lord, in the trial court held, my lord, it was not there. My lord, I am carrying a judgment. My lord, here, my lord, the honorable court held. The moment I raise the question, my lord, question may not be in the
My lord,
form of a pleading.
they are what, my lord, I am on.
Yes, 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 yes.
My lord,
They are what I am.
Yes, 36 was there.
Lord, I am for the appellant petitioner, my lord. Lord,
Yes, Mr. Bota,
Lord,
yes.
this application, short application, since the appeal is otherwise ready for hearing, paper book has been filed and exchanged between the parties. My lord, I have filed an application for early disposal of the appeal because, my lord, appeal,
This is your other side.
my lord, I have served, my lord, one Devasish Bose intended
At the
to
proceeding.
appear in the matter existing learned advocate who is representing the respondent. He is discontinuing. Huh? Service.
The report says you have not deposited the Dolobana.
They appeared on the very first date, my lord. Before you,
No.
my lord, kindly see, my lord, on the
It's a
very
report
first.
of- This is a report of 28th August 2025. One and two, 3, 4, 3, 4, 5 আসেন।
Lord, they entered appearance.
1 and 2 has entered appearance, not 3, 4, 5.
Yes.
Take down. The prayer for early
Judge is appearing for the appellants, my lord, due to some medical urgency, my lord, he left the court. If my lord keeps the matter, my lord, after a week, my lord.
on the prayer of the land council for the appellant, the matter is ended.
Actually, Lordship, this matter, Lordship, is the application in connection with Lordship first appeal arising out of a Lordship partition suit, Lordship. The service has not been done, Lordship. We have to serve upon the opposite party
So after vacation,
after vacation. Lordship.
on the prayer of the land council. Next.
I am about the plaintiff respondent.
There was a direction, my lord, to serve the section 5 application. I have served.
How many days delay?
But 813 days delay. But my lord, may I tell you?
I want to file affidavit, my lord.
May I tell
Kindly
you a
grant me
question?
liberty
Why?
to file affidavit, my lord.
My lord, we are the widow and two daughters of the original defendant. It was a suit for specific performance of a contract. Now, my lord, the suit was filed on 7th of December 2020. Now, my lord, prior to that, the original defendant was a 70-year-old man. Now, my lord, he had suffered a fracture of his hip. My lord, thereafter, my lord, he was completely bedridden. My lord, the legal heirs did not have any knowledge. My lord, thereafter, my lord, he died. Now, my lord,
You have to make an application formally for the addition of these parties.
I shall.
That you have not done because this was filed, when the suit was decreed.
Suit, my lord, during
because
decree of the suit, the original defendant was alive.
after that he died.
After-
So
after-
you have to make an application.
I shall.
because if you file an application, then we'll consider it. Yeah, I didn't 1 week after vacation.
My lord, there is a execution
The
case, my lord,
execution date
filed
is
by
fixed
them.
in the month of December.
Now, my lord, the execution
no hurry.
case is there. My lord, they have sent us a copy of the draft deed. Now, my lord, that is to be registered because my lord,
But
the
you see, this must have been executed by your husband or whoever is there.
lordship. But husband of the appellant number 1 and father of the appellant numbers 2 and 3.
No, but why you are challenging this?
No, my lord, my lord, we are my lord, praying for my lord, setting aside of that decree because my lord, we want to go and contest that suit on merit because it was an ex parte decree.
Expiry decree.
Ex parte decree.
Particularly, he was alive at that time. He
No, my lord,
appeared, he did not file
he
my lord,
admitted,
written
I
statement.
annexed all his documents,
He
a 70-year
What was the consideration amount?
3.5 lakhs, out of which 1.5 I paid.
No, my lord, my
He
case
did not
is
execute the deed.
that the total consideration, my lord, was fixed at 7.5 lakhs. It was not 3.5 lakhs. And the stamp paper, my lord, on which the arranged agreement was
Where is the-
executed,
How much is the area?
But 2 kata something.
Kukata.
Kata.
Where it is?
but it is in
My lord, near my lord, Nimta, Belghoria, that area.
lordship.
How it could be 7.5?
My lord, that
Have
was
you
my lord,
taken
the
Have
sale
you
date, my
taken
lord.
the market value at that point of time? Circle value is available. Circle rate is available.
Yeah, my lord, that is to my lord, at that time, my lord, the Belghoria Expressway, lordship knows, my lord, it
Now
was.
express
Now-
2019.
No, it was in 2020. At that time, my
19,
lord,
19, 20.
construction work was
When
in.
you have
Initially, it was 3 lakhs. Again, he changed the agreement. 50,000 was enhanced. I agreed to that. That was the second agreement
when the second agreement was entered into.
into 2019.
My lord, that is, my lord, the place, my lord,
2019.
Have you given the circle rate of 2019?
but I shall, my lord, because, my lord, these are the widow and the daughters, my lord.
We understand this, but we can stretch ourselves to some extent, not beyond that. We can only request them to. We have done it in the past. We have request them to enhance some amount. That is possible, but we have.
But I
to
shall
have the-
bring the circle rate then, my lord, at that. But only thing is, my lord, my lord, they
My lord, I beg to appear with the appellant plaintiff, my lord. I filed a suit for declaration and for khas possession, recovery of khas possession. So far, my declaration is concerned, that has been allowed.
It has been allowed.
But recovery of khas possession has not been allowed. I am aggrieved that by that part of the judgment and before your lordship. And I have made an application for expeditious hearing of the appeal, and I will pay in the appropriate cost so that the lower court records are brought in and paper books can be
শোনো,
prepared.
yes. Initial order to করে দেবে। Yes. We'll call up to 45 and then we'll rise up to 45. Yes. For the next matter.
number 40,
40 তো হয়ে গেল।
number 41,
You are here. You are appearing. They all file this, mention this matter. When the matter is called, they are not there.
I did not 43, my lord.
No, I'm saying that all of them, these matters. Appear করবে না।
'42,
Yes.
Madam,
remove করেছে।
this appeal, my lord, is against a my lord decree for eviction, but my lord, I am not the tenant. I am one of the co-sharers and my lord pro forma defendant in the suit.
You have been evicted.
No, I have not been evicted. If your lordship would kindly see the last page of the impugned judgment, I am only limited
Now you are the
one of the landlords.
you are one of the plaintiffs.
One of the pro forma defendant. One of the landlord.
It's an appeal by a pro forma defendant.
Millard, only one thing, Millard, very Millard, first time Millard in my Millard, kindly see Millard the last part of the yes, kindly see Millard the last part of the impugned order.
Plaintiffs will take delivery of possession.
Exactly. That is the thing. Plaintiff Millard, they will take
Plaintiffs are different pro forma.
that modification
They are
because
co-sharers.
what we are expecting.
So plaintiffs and
co-sharers are given liberty to execute the deed.
that's what I'm
Because
saying.
Yes.
That only correction. What
I am not against the Millard eviction decree.
he is not against the eviction decree. What he is saying is this. you
Stay
have-
of, pay for stay of operation of the
Arre,
judgment.
nah.
No.
That's-
What he is saying is this. He is a co-sharer.
Yes.
So you are making pro forma defendant. He supports your case. So what he is saying, plaintiffs will take delivery of possession in.
On behalf of the pro forma.
Yes, on behalf of the pro forma.
No,
Yes,
what
yes,
we
no,
are
that is
anticipating,
the point.
he will, once Millard it is evicted, he will Millard induct another tenant of his own choice.
No, that cannot be. That
That
cannot,
of his own choice.
that
Well, kindly make
that
the,
will
we
be-
will also be present,
That's
Millard,
not
we will
taken.
also be
It will be
present
raised
when
later
it
on.
is evicted.
That's not to be raised
But
later
we
on.
will also be present when they are evicted.
it's a We live to learn.
What judge?
We really live
What
to
judge?
learn. Yes.
You are also one of the landlords, no?
আরে ও তো তখন হবে partition.
Against the judgment and decree passed by the learned additional district second court, it whom, my lord. My lord, 27th of March 2025. My lord, I filed the application for stay. I may be permitted to serve the copy.
The state response is right to pay enhanced amount of compensation.
Yes, my lord.
LA case.
That is to be heard by lordship, my lord.
LA case.
Reference cases, my lord.
আমাদের আছে, first appeal court. Have you served them?
No, my lord, if there is no direction for the first time, I'll stay. I may be permitted to serve the stay
It's within time.
within time.
If you want to stay, you deposit the amount.
No, I said, there is no execution presently, my lord. No, I may be permitted to serve the copy.
If you want to stay, the
All
deposit.
right, my lord.
Stay down.
In some more time, my lord.
31st. We have given you enough time. 31st.
Lord,
More than a month.
Lord, plaintiff is the appellant, suit for partition. Lord, my father and my
10 দেখেছি না আমরা of November. 6th of November পড়ে।
Deep love, lord.
ওটা থাকবে 6th of November.
Lord, would your lordship permit me to hand over this? This is print taken on a rough copy. My lord will see the family tree.
No, what
Just
is
to
ma-
explain. Lord, it's a partition.
You are appearing.
No,
It's a partition suit. Plaintiff is the appellant. Lord, suit has been dismissed on the ground that my father and my uncle, they sold not Gopal and Kanailal. Gopal is my father, Kanailal is my uncle. They purchased jointly some properties. But Gopal, they both of them in their lifetime executed gift deed, jointly executed gift deed in my favor.
and sold 2 portions in favor of Agarwals. All these deeds, my lord, demarcate the property and demarcated portion was sold. The court says that since
No, is a suit for partition?
partition, court says,
Challenge the deed.
Lord, it's in my favor.
And then
The deeds are in my favor. Srijit Das, who is the appellant number 1, he is Gopal's son. Gopal and Kanai Lal, 2 brothers, they executed 3 deeds in favor of Srijit. Those 3 deeds have been exhibited. Those 3 deeds demarcate the property which is gifted to Srijit. Those portion were not brought into the hodgepodge of the partition suit. Court says you have not brought in, so the partition is dismissed.
So how demarcation was taken place?
Not, it was, the deed shows that. The deed according to the
All
deed.
parties are agreed.
Lord, the defendant number 5 only contested who is
you excluded those property on the ground that these properties have been gifted or sold to you.
gifted and with demarcation in the deed. The deeds were exhibited.
So
Lord,
these properties you have excluded from the hodgepodge.
yes.
No, but it says that all parties were not made.
Kindly take the Lord portion of the impugned order and kindly take the deed once. Lord, kindly come to internal page 10, 11 and 12. Lord, Gopal and Kanai Lal, they were the owners of the property, undisputedly. I am Gopal's son.
You have filed the suit. Is a suit by Kanailal.
No, not sued by Kanai. Can I take the cause title once? Lord, sued by Srijit and Sutopa and Sheila, they are the legal heirs of Gopal. Now, Gopal and Kanai Lal, Lord, kindly have a look at this. I go down at it.
No, so this is amongst the parties, legal heirs of the parties.
Legal heirs and two portion was sold to Agarwals. But those are demarcated portions. Kindly have a look at the deed once. Now everybody agreed to the partition.
Done in presence of all the co-sharers of the property.
They were the only owners then. Gopal and Kanailal, they sold by demarcating. Kindly have a deed of one deed. Take one deed. Kindly take one deed. Kindly have a look at once. So Gopal and Kanai were the owner, court accepts. There is no other co-sharer. They, while they were living, they gifted me, the appellant number 1, by 3 deeds, some portion by demarcation, and sold to Agarwals 2 portions of the properties. They demarcated in the deed. They died. They passed away. They are legal heirs. I filed the partition suit.
Unless you say by reason of this, outside of possession of the other co-owners.
In the plain, that case was made out that it is transferred.
Unless you make that there is a clear case of outside of possession, outside of the co-sharers, then every inch they have a right.
Yes, yes.
So it's only a variation of the shares.
Yes, but
It's not more than that. It's only a variation of
yes,
the shares.
that was
But you
pleaded.
cannot say that I will have only this.
No, I am not saying that. But
You have filed a partition suit.
Yes.
Of legal heirs.
yes,
Of the 3 persons.
of Gopal and Kanai,
Yes, Gopal and Ganai.
Yes.
Who have maybe purchased.
who purchased say 10 bighas of land.
10
Amongst
bighas
that
of-
10 bighas, while they were living, they sold 1 bigha to X, 1 bigha to Y by demarcating.
Purchased 10 bighas of land from XYZ. So these 10 bighas demarcated.
These 10 bighas demarcated, then they demarcated 1 or 2 bighas in favor of X and Y. They sold it
And the
and
remaining,
gifted 3 bighas to me by demarcating. So remaining 5 bighas partition filed.
no, demarcated mutual demarcation, is there any settlement?
In the deed itself, both of them executed the deed. It's a demarcated portion was sold.
So the portion which was left,
That is only the hodgepodge of partition, and only the defendant number 5 contested. He agreed for the partition in the written statement. In the written statement, kindly take the stay application once. The written statement of defendant number 5, page 34. Kindly take page 35 of the stay injunction application. I am reading it for your lordship. Para 9. Defendant number 4 and 5 are always ready and willing to make partition of their respective shares with the plaintiff, but it is also noted that on several meetings with the plaintiff, defendant number 4 and 5 will want to take total cream of the land, that is the front portion. That is for the commissioner of partition to decide. The suit should not fail. 1A, 1B filed written statement, they did not contest. In page 10 of the impugned order, I will find that the court records the page 8 that the defendant number 5 only contested. Page 8 of the impugned judgment. কমেন্ট করছে আদিত্য কাছ থেকে আমি বললাম বলতে না পারলে বলে একটু দাঁড়া না only defendant 5 Nita is legal here. What happened is Gopal Kanai and the others are brothers and sisters. Take that family tree once. Oh, here, nine. I go down. I go down. রাফে প্রিন্ট করা ম্যালড তোমাদের কাছে হবে না পাঁচটা ডিডি আছে
তিনটে ডিগ্রি আছে
তিনটে ডিডি আছে তো
তিনটে ডিগ্রি
It's were exhibited as exhibit 4, 5 and 6. The court says there is no document.
page 2
partition হচ্ছে partial partition হচ্ছে
একটা ট্রি বানিয়ে আনবি কাকে কাছে করে আনবি সময় নেই clarity করার এখানে বলে দিলাম only 5
that is the parties who have been swept to whom you have sold
yes
also become co-sharer.
yes Vijit is a co-sharer. Jaiswals are not parties, my lord. Jaiswals are not here. They were demarcated, sold, they left.
Left or demarcate, that's when a partition is there, then there's no question of demarcation comes.
My lord, kindly allow me to say only one thing. Gopal and Kanai purchased.
No, we understand what you say.
They sold something by partitioning, by demarcating to others. The
Then
rest
serve
portion
and
is in the
combat.
Lord.
Serve and combat.
Yes, Lord. Only status quo to be maintained, Lord. In the meantime, is all between the co-sharers.
Serve for the
দিয়ে দেবে কবে থেকে চাইছি
ক্যাবিনেট নোট নেই কেন
Lord, should we serve
yes,
court below the learned lawyer in the court below also should we serve in the learned?
whatever you feel, but parties has to be served. What is this matter?
For the appellant, can 2 is an application for condonation of delay.
Have you
and can-
served? Have you
No,
served?
first time.
No, condonation has to be served.
Yes, definitely. But both the kindly, that is both the application.
কাজ করো ওই যে এমনি অর্ডারটা দিলাম the application for condonation of delays